back, and thanks for tuning in to In Depth with Academia. I'm Richard of .edu, and today we're taking a fascinating look into the world of digital forensics, volatile memory, and the landscape that's rapidly evolving alongside focusing on a paper by P. Bellisan titled The Jurisprudence of Volatile Memory, Adjudicating Unauthorized Access, Ephemeral Spoliation, and Theensic of RAM and ESI Remember. As always, I'll presenting this paper neutrally. I'm not endorsing it, but exploring what it has to say, what questions it, and what might for each of. So let's get into the core question. The essentially, when information is stored RAM or random access memory, does it count as under modern legal rules? What the implications for both civil and criminal investigations? Why does it matter those fleeting bits of memory discoverable in? This is because computers and digital play role in pretty much every aspect of our lives now, but RAM is tricky, switch the power and it's gone in a blink. To treat this evaporating memory as real evidence, and if so, under what circumstances? Now, why this matter for you? Maybe you're in IT, or you're involved in legal work around digital systems, or possibly you just want to know if what's in your computer's RAM could back to haunt, or help in court, right? Growing importance of memory forensics is kind of wild. I'm not just talking about a new save to your hard drive, but about what happens in temporary, between spaces while working or browsing online. Let Talk Methods, the author Bellisan, reviewed landmark courtings, including Columbia Pictures Industries v. Bonnell. Court decided that if data can be fixed from RAM to some kind permanent storage, and it's technically feasible to do so, then that information in RAM is discoverable. Think server logs that only ever exist in RAM, or user activity that never gets written out to disk. The court said, well, if could be saved, then it probably should be preserved. Litigation is a possibility. On the other hand, if it's just not technically feasible, like in Convolve v. Compaq, the duty to keep that information can a lot weaker. It's not absolute, it's all about capability and what's reasonable. Then there's this really fascinating bit about trade secret disputes that only looked I didn't take defense. Someone accesses a secret document and claims they merely read it but didn't copy or download it. The paper How Traditional Disk Forensics Can't Disprove That Claim, since sometimes things never touch the drive. But forensics swoops in here, capturing what's in RAM can show the contents of a clipboard or active network connections showing data flowing out to an unauthorized location, or the decrypted version of a file currently open on the desktop. That's concrete evidence you can't get otherwise. Okay, side note, has anyone else copied to their clipboard and then frantically tried to find it again? Can you imagine a world where someone's job is looking for that one thing you copied, you can't remember, buried in RAM? Anyway, the paper dives into another major defense, the called Trojan horse argument. This is where someone says, yes, they came from my computer, but it was a virus, a hacker, or something outside my control, a case, Regina. Aaron Caffrey, the defendant, actually got off because didn't seize live snapshot. Without RAM evidence, they couldn't prove or disprove whether his had been hijacked at the moment of attack. If you're with modern malware, so much of it is fileless, meaning it lives and dies in RAM, never disk. Cap memory at the right time is crucial. And the stakes even, if you fail to preserve volatile evidence when you're supposed to, you could face sanctions in court under rules like Federal Rule of Civil Procedure 37E. Not saving that RAM can, to anything from smaller penalties all the way up to the judge telling the jury to assume the worst about you, or even dismissing your case. Timing, process, even how save hash the RAM image, all that is outlined best practice. The moral here isn't law is terrifying. Even it sounds that way sometimes, but really that we're all still figuring this out. Okay, let's pull back, reflect. So, how does this affect you, the listener? If deal with sensitive business data, health info, just want to know what's at stake when computer's running, you should that what happens in RAM isn't necessarily invisible anymore. The technical and legal world is shifting, and the choices we make around memory capture, system shutdowns, or clipboard use can have downstream. But don't panic. This is about living in fear, but being mindful of best practices and asking questions. Again, I want to make it clear, I'm just neutrally exploring Bellisons, not endorsing them. Academic research gives us tools to think with, not eternal answers, as certainties could be. We got that wrong, actually. So be curious, dogmatic, for joining me in depth with. I hope you're walking away with food for thought, whether you're a techie, a lawyer, or someone fascinated by this intersection of law and the digital world. Until next time, keep questioning, keep learning, and maybe double check what's in your clipboard before you log off.